Montana is set to become the first state in the United States to completely ban TikTok after Republican Governor Greg Gianforte signed the bill into law Wednesday. For more on that, let's bring in CBS News legal contributor Jessica Levinson. Jessica, it's good to be with you again. We're going to talk about Montana and California. We're going to start in Montana. What are the potential First Amendment issues with this law banning TikTok in Montana?
Well, they're very significant here. As you said, I think you use the exact right words, complete ban. And Montana is saying you can't use TikTok in this state. You can't download it. You can't offer it. Now, there's huge devil in the details in terms of how they'll enforce it. But this is a state saying we are trying to eliminate one of the communication platforms. And that obviously does raise really serious First Amendment concerns. John, as you know, the First Amendment is not absolute. We have carve out to it. That's why I teach a whole semester on the First Amendment. If it was absolute, it would be a one-day class. One of those carve outs is for national security, potentially immediate threats to national security. I'm not sure that the evidence is there that indicates that TikTok does present that kind of threat. And you mentioned, Jessica, the enforcement issue. How would this be enforced? I think that is, at this point, a huge question. It will probably be easier to go after Google and Apple in terms of whether or not they're offering downloads than it would be to try and go after any sort of users. And that's why I think the legislation is really written to punish TikTok and Google and Apple, not the users, because again, that would just be an administrative nightmare. It's already difficult enough to try and figure out who's actually downloading from an app store, particularly when there are workarounds and you can try and basically create a private network to make it look like you're in a neighboring state downloading that app. Sure, exactly. Just ask any 13-year-old. All right, so let's go to Florida now, Jessica. There are basically PEN America, which is an advocacy group for writers, and Random House have sued Florida for its ban on books. What's behind that case? This is our First Amendment segment here. So this is another First Amendment challenge where what PEN America and some parents and some authors and Random House are saying is that there's a school district in Florida and that they are violating the First Amendment and the 14th Amendment by taking certain books either temporarily or permanently off of the shelves. And what they're saying is the First Amendment concern is based on both the speaker, the authors that want to basically speak to the audience by allowing their books to be offered, and also the listener, that children, that the audience, that the listeners can't obtain that information because the books are pulled off the shelves. There's also a 14th Amendment issue here because what the lawsuit says is you're targeting books disproportionately just based on LGBTQ issues and racial issues. So those are the two interests at issue here. And then going back to your earlier point, the First Amendment is not absolute. So what's the best defense against this lawsuit by PEN America and Random House? The First Amendment is not absolute. So now, of course, we're not talking about national security. We're talking about carve-outs that allow, for instance, school districts to create certain community standards. And we're talking about carve-outs for things like pornography and obscenity. And again, I think what will be litigated is whether or not the particular law at issues that allow school districts to take certain books off of the shelves, whether or not those laws are being applied in an equal way and whether or not they're overbroad. CBS News legal contributor Jessica Levinson, thanks so much for being with us. Thank you.